Good afternoon, everyone. Welcome to the Assembly Committee on Commerce and Labor. Madam Secretary, will you please call the roll?
Assemblywoman Carlton? I'm here. Assemblywoman Considine? Here. Assemblywoman Dickman? Here. Assemblywoman Duran? Here. Assemblyman Flores? Present. Assemblyman Frierson? Here. Assemblywoman Hardy? Assemblywoman Kasama? Here. Assemblywoman Martinez? Present. Assemblywoman Marzola? Here. Assemblyman O'Neill? Here. Assemblywoman Tolles? Here. Chair Howdigi?
Here, thank you, Madam Secretary. Please mark Assemblywoman Hardy absent excused. Okay, members, I think everyone is familiar with our housekeeping items, so I'm just going to go ahead and skip those so that we can get straight into our agenda items. We only have a couple items on our agenda, work session and public comment, and we can move straight into our work session. We are going to take everything in order with the exception of Senate Bill 186. The senator has requested that we take that last so that she can be present and hopes that Senate floor ends so that she can make it here. With that, I'm going to turn it over to our policy analyst, Ms. Pasloff-Thomas, to walk us through Senate Bill 44.
Thank you, Madam Chair. Margie Thomas with the Research Division. The first bill is Senate Bill 44, and it revises provisions governing behavioral health professionals. It was sponsored by the Senate Committee on Commerce and Labor on behalf of the Rural Regional Behavioral Health Policy Board. There are 5 proposed amendments by Senator Goycochea, and there is a mock-up attached behind the bill pages. This mock-up is different than the one that was referenced during the committee hearing. The mock-up below actually includes what is being proposed in the amendment. So the first is to amend the bill to revise provisions concerning the issuance of an expedited license by endorsement by the boards that are referenced in the bill for the purpose of A, combining sections governing expedited licensure or certification by endorsement for a general applicant with sections governing licensure or certification by endorsement for an active member or the spouse of an active member of the Armed Forces of the United States, a veteran, or the surviving spouse of a veteran. B, revising certain requirements for issuing an expedited license by endorsement. C, authorizing the applicable boards to grant a provisional license at any time before making a final decision on an application for a license by endorsement in accordance with the regulations adopted by the regulatory body. And D, making conforming changes so that active members or the spouses of active members of the Armed Forces of the United States, veterans, and the surviving spouses of veterans continue to receive reductions in fees. The second proposed amendment is to add new provisions to Chapter 641, 641A, 641B, and 641C of NRS to require the applicable boards to provide an alternate means for an applicant to submit official transcripts if 1, the college or university from which the applicant graduated has closed or merged with another institution, and 2, the provision of official transcripts by ordinary means is not available or possible. The third proposed amendment would add new provisions to Chapter 641, 641A, 641B, and 641C of NRS, requiring the applicable boards to adopt regulations authorizing remote supervision, including electronic supervision, and prescribing standards for such remote supervision. The fifth proposed amendment amends Sections 3, 6, 12, and 24 of the bill to require each board to submit the specified report to the chair of each regional behavioral health policy board, and 2, authorize the report to be submitted in a written format. And the final proposed amendment is to delete Section 32 of the bill. Thank you.
Thank you, Ms. Pasloff-Thomas. Members, any questions on the bill or amendment before you? Ms. Tolles.
Yes, thank you. And I just wanted to confirm, so in the original mock-up, we had a section 2.5D that added the requirement to put prohibited crimes on the website. And I do see that in this mock-up that is not there. And so I just want to confirm that that has been removed.
Correct, and we did get that section removed. I shared the same concerns that you had, Assemblymember Tolles, and when I submitted the request to our legal and our policy analyst too, I had the same questions when I saw the work session document to make sure that all the sections where we all had concerns on, Vice Chair Carlton, myself, and you were taken care of.
Thank you, Chair. I appreciate it.
Thank you, sir. Okay, members, any other questions? Okay, seeing none, I would accept a motion to amend and do pass. So moved. I have a first by Vice Chair Carlton. Do I have a second? I'll second. I have a second by Assemblymember Marzola. Any discussion on the motion? Okay, seeing none, all those in favor, please signify by saying aye. Aye. Opposed? Motion carries. I will assign that floor statement to Assemblymember Kasama. Okay, next item on our agenda is Senate Bill 75. Ms. Pasloff-Thomas?
Senate Bill 75 revises provisions relating to unemployment compensation. It was sponsored by the Senate Committee on Commerce and Labor on behalf of the Department of Employment, Training, and Rehabilitation. It was heard on May 12th. There are 4 proposed amendments which were discussed during the bill hearing. The first is by Dieter, and that would be to amend Section 5.5 of the bill to replace the United States Department of Labor with federal law. The second proposed amendment amends subsection 2 of Section 19.5 of the bill to require the amount of payment by way of reimbursement in lieu of contributions due by an employer who has elected to make payments by way of reimbursement in lieu of contributions to be reduced by an amount of state liability relief for the weeks of unemployment beginning on or after March 13th, 2020, at an amount prescribed by the administrator. It also requires the administrator to determine such amount so as to utilize all available relief pursuant to Section 903I of the Social Security Act of 1935 and result in such employers owing no amount for the weeks that such relief is available. John Piro with the Clark County Public Defender's Office and Kendra Birchie, also with the Washoe County Public Defender's Office, propose the third and fourth amendment, and that would be to require the administrator to, in response to a request from a court official with subpoena authority and in compliance with federal law, furnish certain information concerning persons who receive benefits for use in the selection of trial jurors in Section 3, and the fourth is to delete Section 19 of the bill.
Thank you so much, Ms. Pasloff-Thomas. Members, any discussion on the bill or amendment before you? Okay, seeing none, I would accept a motion to amend and do pass.
Thank you, Madam Chair. I would move, amend, and do pass.
Any seconds? Second. Okay, I have a first by Vice Chair and a second by Assemblymember Martinez. Any discussion on the motion? Okay, seeing none, all those in favor, please signify by saying aye. Aye. Opposed? Okay, motion carries. I will assign that floor statement to Assemblymember Martinez. Thank you, Chair. Okay, next item on our agenda is Senate Bill 141.
Senate Bill 141 requires provisions relating to public works. It is sponsored by Senator Brooks, heard on March 7th, and there are no proposed amendments.
Okay, any discussion on the bill before you? Okay, I have a first by Vice Chair Carlton and a second by Assemblymember Dickman. Any discussion on the motion? Okay, seeing none, all those in favor, please signify by saying aye. Aye. Opposed? Motion carries. I will assign that floor statement to Assemblymember Dickman. Okay, next on the agenda is Senate Bill 179.
Senate Bill 179 revises provisions relating to sign language interpreting and real-time captioning. It was sponsored by the Senate Committee on Commerce and Labor on behalf of the Legislative Committee on Senior Citizens, Veterans, and Adults with Special Needs. It was heard on May 12th, and there is one proposed amendment by the Clark County School District, and that is to amend Section 18 of the bill to change the expiration date of a provisional registration issued pursuant to this section from July 1st, 2024 to July 1st, 2026.
Thank you so much, Ms. Pasloff-Thomas. Members, any questions about the bill before you? On the bill before you? Okay, I have a first to amend and do pass by Vice Chair Carlton. Do I have a second? I have a second by Assemblymember Marzola. Any discussion on the motion? Seeing none, all those in favor, please signify by saying aye. Aye. Opposed? Motion carries. I will assign that floor statement to Assemblymember Marzola. Okay, next on our agenda is we have Senate Bill 181.
Senate Bill 181 revises provisions relating to alcohol and drug counselors. It is sponsored by Senator Goycochea, heard on May 5th, and there are no proposed amendments.
Okay, members, any discussion on the bill before you? I have a motion to move do pass by Vice Chair Carlton. Do I have a second? Have a second from Assemblymember Dickman. Members, any discussion on the motion? Okay. Well, we'll make sure it's here for a long time for you, Vice Chair. Okay, all those in favor, please signify by saying aye. Aye. Opposed? Motion carries. I will assign that floor statement to Assemblymember Tolles. Okay, members, next item on the agenda is Senate Bill 184.
Senate Bill 184 revises provisions relating to the practice of medicine. It is sponsored by Senator Hardy. It was heard on May 3rd. There is one proposed amendment by the chair, and that is to delete sections 2 and 24 of the bill, which authorizes the Board of Medical Examiners and the State Board of Osteopathic Medicine to issue a license to practice medicine or a license to practice osteopathic medicine, respectively, to certain persons.
Okay, members, any discussion on the bill or amendment before you? Okay, I have an amend and do pass by Vice Chair Carlton. Do I have a second? I have a second by Speaker Frierson. Any discussion on the motion? Okay, all those in favor, please signify by saying aye. Aye. Opposed? Motion carries. I will assign that floor statement to Assemblymember Considine. Okay, we are going to move past 186 and save that for the last work session bill. So we're going to jump into Senate Bill 190.
Senate Bill 190 provides for the dispensing of self-administered hormonal contraceptives. It is sponsored by Senator Cannizzaro. Are two proposed amendments by the sponsor, and a mock-up is attached. The first is to delete Section 8, which requires the Chief Medical Officer to issue a standing order to allow pharmacists to dispense a self-administered hormonal contraceptive to any patient, and 2, the State Board of Health to prescribe a protocol for dispensing a self-administered hormonal contraceptive. Instead, require the State Board of Pharmacy to adopt certain regulations establishing a protocol to allow a pharmacist to dispense a self-administered hormonal contraceptive to any patient. Make conforming changes throughout the bill to account for the deletion of Section 8 and the establishment of the protocol by the State Board of Pharmacy. The second proposed amendment is to add Assemblywoman Considine as a co-sponsor of the bill.
Okay, members, any discussion on the bill or amendment? Okay, I have a first by Speaker Frierson. Oh, yes, I thought you were making them. Okay, Assemblymember Dickman, yes.
Thank you so much, Chair. I still have some concerns about especially minor children getting birth control dispensed without seeing a doctor. So I'm going to be a no right now. I might change on the floor, but
Thank you, Assemblymember
Thank you.
Dickman. Members, anyone else? Okay, I have a first by Speaker Frierson. Is amend and do pass. To amend and do pass. I have a second by Assemblymember Considine. Any discussion on the motion? Okay, members, all those in favor, please signify by saying aye. Aye. Opposed? Nay. Okay, I have a nay by Vice Chair Carlton and a nay by Assemblymember Dickman. A motion carries. I will assign that floor statement to Assemblymember Considine. Okay, next we have Senate Bill 217.
Senate Bill 217 revises provisions related to applied behavior analysis. It is sponsored by Senator Sievers-Gansert, and it was heard on May 5th. The senator is proposing one amendment, and that would be to amend Section 55 of the bill, which removes provisions requiring the board to prescribe by regulation fees for the issuance, renewal, and reinstatement of a license or registration and any other service provided by the board. Instead, it requires the board to establish a schedule of fees and charges for certain specified items relating to licensing and registration with certain specified maximum amounts, which are based on the type of fees and amounts currently charged by the Aging and Disability Services Division of the Department of Health and Human Services as set forth in Section 10 of the LCB's file Regulation Board of Applied Behavior Analysis, with the following exceptions. And that would be to set the maximum amount of a fee that may be charged for the biennial renewal or reinstatement of a license as a licensed behavior analyst at $550, a license as a licensed assistant behavior analyst at a maximum of $425, and a registration as a registered behavior technician at $100. This does not include a fee for the examination for licensure as a behavior analyst or assistant behavior analyst.
Thank you, Ms. Pasloff-Thomas. And before I go to members for questions on the bill, I know I got my question answered by, I'm assuming, just to put this on the record, it was my request that, and Vice Chair's concern too, that we add the fees to statute. I know we only see some fees listed here, but the amendment that was requested would require that all of their fees be in an RS, correct?
Correct. It's the ones that you see in Section 10 of the regulations.
Thank you so much. Okay. Members, any other questions on the bill or amendment before you? Okay, seeing none, I would look for a motion to amend and do pass. I have a first by Vice Chair Carlton. Do I have a second? I have a second by Assemblymember Marzola. Any discussion on the motion? Okay, all those in favor, please signify by saying aye. Aye. Opposed? Okay, motion carries. I will assign that floor statement to Assemblymember Duran. Okay, next item on our agenda is Senate Bill 247. No, it's okay.
Sorry about that. Senate Bill 247 revises provisions relating to apprenticeships. It is sponsored by Senator Dondero Loop, heard on May 7th, and there are no proposed amendments.
Members, any discussion on, or any questions on the bill before you? Okay, I would look for a motion to do pass. I have a first by Vice Chair Carlton. Do I have a second? I have a second by Assemblymember Duran. Any discussion on the motion? Yes. Go ahead. Mm-hmm.
Thank you, Chair. And I was looking for amendment on the very last sentence in this bill in Senate Bill 247, because that was the one we asked some questions about and had some concerns. I still have some concerns, even though I appreciated the discussion. So for those reasons, I'm going to be voting no. Thank you.
Thank you. Members, any other discussion? Okay, all those in favor, please signify by saying aye. Aye. Opposed? Will the nays please raise their hand? I have Assemblymember O'Neill, Assemblymember Kasama, Assemblymember Dickman, and Assemblymember Tolles as a nay. Motion carries. I will assign that floor statement to Vice Chair Carlton. Okay, next we have Senate Bill 269.
Senate Bill 269 revises provisions relating to dental insurance. It is sponsored by Senator Kiekeffer and heard on May 3rd. There is one proposed amendment by Paul Klein, and that is to amend subsection 1G of section 5 and subsection 1G of section 11 to delete the requirement that in order to deny a claim for which prior authorization was granted because the insured was not eligible to receive the dental care for which the claim was made, the dental insurer or administrator must not have known of the eligibility status of the insured and cannot have discovered the eligibility status of the insured through reasonable care. Thank you.
Thank you. Members, any questions? Vice Chair?
Thank you, and thank you, Madam Chair. This amendment reads a little wonky, but I believe it actually gets to the point. The committee had concerns about folks going in. Eligibility and prior authorization are not necessarily the same thing. They're not all in real time. So I think this addresses the issue to make sure that the dental practitioner knows the rules of the road and the patient knows the rules of the road when they go in to get these procedures taken care of. So I'm really hoping this says what I think it says. Thank you.
And I believe we might have Mr. Klein here. Did you want to? Okay, perfect. Okay, thank you. Then at this time, I would look for a motion to amend and do pass. So moved. I have a first by Vice Chair Carlton. Second? Second? By Assemblymember O'Neill? Okay, perfect. Any discussion on the motion? Okay, all those in favor, please signify by saying aye. Aye. Opposed? Okay, motion carries. I will assign that floor statement to Assemblymember O'Neill. Next, we have a Senate Bill 289.
Senate Bill 289 revises provisions relating to workers' compensation. It is sponsored by Senator Harris, heard on May 7th, and there are no proposed amendments.
Members, any questions on Senate Bill 289? Seeing none, I would look for a motion to do pass. I have a motion to do pass from Vice Chair Carlton. Do I have a second? I have a second from Assemblymember Considine. Any discussion on the motion? Okay, all those in favor, please signify by saying aye. Aye. Opposed? Okay, motion carries, and I will assign that floor statement to Assemblymember Considine. Okay, next we have Senate Bill 303.
Senate Bill 303 revises provisions relating to professions. It is sponsored by Senator Brooks and Spearman, and it was heard on May 5th, and there are no proposed amendments.
Any questions on Senate Bill 303? I have a move to pass by Vice Chair Carlton. Second? I have a second by Assemblymember Duran. Discussion on the motion? Okay, all those in favor, please signify by saying aye. Aye. Opposed? Motion carries. I will assign that floor statement to Assemblymember Flores. Okay, next we have Senate Bill 307.
Senate Bill 307 revises provisions related to the sale of alcoholic beverages. It is sponsored by Senator John Darrell-Loop, and it was heard on May 10th. There are several amendments. Mr. Alonso proposes the first 5, which are attached. The first is to amend Section 1 of the bill to change the time in which the supplier is required to approve a specified transaction from 30 days to 60 days, require approval or denial to be in writing, and if denied, require the writing to state the material reasons for the denial, and 3, provide that the failure to approve or deny within 60 days has the effect of approving the request. Second, amend subsection 9 of Section 3 of the bill to remove the provisions prohibiting a supplier from requiring a wholesaler to keep a certain minimum inventory. Instead, prohibit a supplier from requiring a wholesaler to make payment for the purchase of any malt beverage until at least 7 days after the delivery or under the terms of the credit policy, whichever is greater. Provide an exception from this prohibition for situations involving a wholesaler who has failed to make a payment to the supplier on or before the due date. The third would be to amend Section 3 of the bill to provide that a waiver of any provision of NRS 597.120 through 597.180 is void and unenforceable. Fourth is to amend subsection 13 of Section 3 of the bill to delete the specified prohibition concerning payment terms between a wholesaler and a supplier. Instead, it prohibits a supplier from failing to 1, pay a wholesaler for invoices or claims for reimbursement within 30 days after approval by the supplier, or 2, approve or disapprove such invoices or claims within 30 days after receipt. The fifth is to amend Section 7 of the bill to provide that the provisions concerning the unlawful possession, sale, or transportation of liquor set forth in subsection 1 do not apply to licensed original package retailers or their delivery support services while acting in their professional capacities to deliver to consumers liquor that the original package retail liquor store purchased from a state licensed wholesaler and within the retail liquor store licensee's jurisdiction. It requires the Department of Taxation to adopt regulations setting forth certain specified requirements governing such delivery. The other proposed amendment comes from Senator Goycochea, and that would be to amend NRS 597.240 to 1, authorize the activity specified in subsection 1 to be engaged in at a licensed non-contiguous location of a winery within Nevada, 2, revise the provisions of the section concerning the percentage of wine that is produced, blended or aged by a winery from fruit grown in the state to also take into account wine that is produced, blended or aged from honey produced in the state, and 3, authorize certain wineries to sell alcoholic beverages to consumers on their premises, so long as the winery has obtained a retail liquor store license from the city or county in which the winery is located and complies with certain requirements relating to the purchase of liquor from a licensed wholesaler. Thank you.
Thank you, Ms. Pasloff-Thomas. Members, questions on the bill before you? We will start with Assemblymember Tolles.
Okay, I'm going to try and make Vice Chair proud of my humor here, but if whiskey is for drinking and water is for fighting, then wine is for making you dizzy, because this amendment is certainly has a lot going on, and I am very appreciative of the, I know particularly a certain mead distributor that is excited about the pieces in Senator Goycochea's amendments, and there's some pieces that I really like in these amendments. Unfortunately, though, I have some real concerns about the invoices and some of the specific transactions. in ways, the added language in this amendment that unfortunately has caused me to have to be a no, but I will reserve my rights certainly if we can work that out, because I'd like to be a yes, but unfortunately I'm a no. Thank you.
Thank you, Assemblymember Tolles. Speaker, did you have I'm going to go to Speaker Frierson next.
Thank you, Madam Chair. I just wanted to point out procedurally where we are. If we consider this without the amendments, then that's the end of the conversation. And so I think from a procedural standpoint, there are some unresolved questions. I think that there are some significant concessions that have been made, but otherwise this allows us to continue to have that conversation. And what I don't want to do is cut that off. And so while I have a little bit of concern about what I have received is not necessarily everybody being on the same page, I do recognize concessions that have been made, but in the big scheme of things, I recognize that by agreeing to amend and send it back, it allows for the conversation to continue and for some of these issues that seem to be confusing to a little bit more time to be worked out, and in particular by the sponsor in the sponsor's house. And so for that reason, I think while there's more conversation that needs to take place, possibly I'd like the conversation to continue. So I'm going to be supporting it.
Thank you, Speaker Frierson. I'm going to go to Assemblymember Kasama next.
Thank you, Chair. Yeah, there's so much of this bill that I really like. I think there's a lot of good things. I am concerned with restricting the ability to check creditworthiness of somebody when you're extending credit, which I think is fairly common for businesses. And so unfortunately, I'll be a no at this time with right to reserve to change on the floor. Thank you.
Assemblymember Dickman.
Thank you, Chair. I find this amendment and this whole thing kind of confusing. I think I'm seeing something about putting mandatory credit in statute. I'm not sure I like that. But at this point, I'm going to be a yes, reserve, because especially I like the wine part. Thank you.
Vice Chair Carlton.
And thank you, and I understand where some of the concerns are, but when you have to have a mandatory stock, when you do business with these folks, they tell you how much you have to buy. In no other business does your vendor tell you, you must buy 300 cases of this, 200 cases. Well, it's not fair to mandate how much you have to buy and not give you the credit to do it. So to me, that's a two-way street. So I understand where some of the concerns are, but you know, whenever this legislature gets involved in the three-tier system and these guys, things always get a little bit confusing, but they don't operate like any other business does in this state for a reason, because we put in safeguards for it. So we just want to make sure that it's a level playing field for everyone. And I want to thank Senator Gokachia for his hard work. He had to really talk a lot to convince me to take some of these amendments, and it's just because it was him am I doing this. Otherwise, I would not have gone down this road. So whoever benefits from this, thanks Senator Gokachia for it, because he worked his butt off convincing me to support this bill.
I'm going to ditto the amendment from what my vice chair said. Senator Gokachia fought a good fight. Okay. Assemblymember O'Neill.
Thank you, Chair. I'm just going to say ditto, and when I sober up from this, I'll try to get to a yes. Thank you.
Okay, I would look for a motion to amend and do pass. I have a first by Vice Chair Carlton, a second by Assemblymember Martinez. Any discussion on the motion? All those in favor signify by saying aye. Aye. Opposed? Well, the nays raise their hand. I have a nay from Assemblymember O'Neill, Assemblymember Kasama, Assemblymember Tolles. Motion carries. I will take that floor statement. Okay, next bill on our agenda is Senate Bill 320.
Senate Bill 320 enacts various provisions relating to food delivery service platforms. It is sponsored by Senator Neal, and it was heard on April 30th. There are 4 proposed amendments, and the first is to amend the definition of food delivery service platform in Section 4 of the bill. The second is to amend subsection 1C of Section 16 to delete the requirement that the specified statement include a disclosure of the average commission. The third proposed amendment amends Section 19 of the bill to, 1, lower the limit of the maximum commission that may be charged by a food delivery service platform during provider from 20% to 15%. 2, provide that the limitation on the maximum commission that may be charged is effective only in a county in which a declaration of emergency is in effect, which includes social distancing or other occupancy limitations on capacity in a food dispensing establishment. And 3, provide that the provisions of this section do not preempt any local ordinance which places limits on the maximum commission that may be charged, so long as such ordinance was in effect before April 30th, 2021. And finally, amend the effective date of the bill to upon passage and approval.
Thank you so much, Ms. Pasloff-Thomas. Members, any questions on Senate Bill 320 and the amendment? Okay, seeing none, I would look for an amend and do pass. I have a first by Vice Chair Carlton, a second by Assemblymember O'Neill. Any discussion on the motion? Okay, all those in favor signify by saying aye. Opposed? Okay, motion carries. I will assign that floor statement to Assemblymember O'Neill. You're welcome, Assemblymember. I know you were a big fan of that bill. Okay, members, we are going to revisit Senate Bill 186. It does not look like the Senate has adjourned floor yet, so we are going to go ahead and take Senate Bill 186. And Ms. Pasloff-Thomas?
Thank you, Madam Chair. Senate Bill 186 revises provisions relating to collection agencies. It was sponsored by the Senate Committee on Commerce and Labor and heard on May 10th. There are 3 proposed amendments by Senator Spearman. The first is to provide that if a homeowners association uses the foreclosure process, the home may not be sold to 1, any person who is involved in the foreclosure process, including without limitation, a collection agency used by the HOA to collect an obligation relating to the property, a community manager of the HOA and his or her assistants, an HOA board member, and an attorney who represent any of the parties with regard to the foreclosure, or 2, any person who is related within the 3rd degree of consanguinity to a person described in item 1. For purposes of this provision, any person who is involved in the foreclosure process means any person who exercised discretion in any decision relating to the foreclosure of a lien, and any person employed by such a person. The second proposed amendment requires an HOA to send its notices and communications by mail and to the electronic mail address designated by a unit's owner, unless the unit's owner has opted out of receiving electronic communications or has not designated an electronic mail address. And the third is to require each HOA in a common interest community that has 150 or more units to establish either a website or electronic portal which may be accessed by its members. Specifically, the provision would provide that beginning on January 1, 2022, each OA in a common interest community that has 150 or more units must establish a website or portal and post on the website or portal documents which relate to the HOA, including without limitation the most recent copy of the CC&Rs, the HOA bylaws and rules, the articles of incorporation, the annual budget, any proposed budgets, notices, and agendas of upcoming meetings, and any other documents required by regulation to be posted. And beginning on January 1st, 2023, these HOAs must establish on the website or portal the ability for units owners to pay their assessments online, and homeowners associations with less than 150 units are authorized and encouraged to create such website or portals. Thank you.
Members, any questions on the bill or amendment before you? Okay, I would look for, Assemblymember Tolles.
I was waiting for the vice chair because I thought maybe she would ask a question about it too. But in regards to the portal and the website, okay. So it's, as I read it, it's my understanding that it is mandatory to have either a website or a portal for communities with over 150 units, but then it is encouraged to create such a website or a portal. So if I could just get a little bit more clarity around that, that would be appreciated.
Yes, and it's encouraged, and I believe if I read it correctly, it was the encouraged was for those who have 150 or less. So mandatory for those with 150 or more, and encouraged for those with 150 or less. If you guys look at this work session document, compare it to what was originally proposed at the hearing earlier this week, it had originally been for HOAs with 100 homes or less, and in working with the industry partners, in order to bring them into a neutral position, they just requested it be 150.
Wonderful. Thank you, Chair. And then I knew there was a little bit of concern around Section 1 with the requirements of gathering that reporting data, but it's my understanding that those HOAs would already have that information. This is really just sending it to somewhere so that we can review it, correct? Correct. Okay, thank you so much. I appreciate it. With that, I will be in support.
Thank you, Assemblymember. Members, any other questions? Okay, seeing none, I would look for an amend and do pass. So moved. I have a first by Vice Chair Carlton. Do I have a second? I have a second by Assemblymember Marzola. Any discussion on the motion? Okay, all those in favor signify by saying aye. Aye. Opposed? Well, I have an opposition from Assemblymember Kasama and Assemblymember Dickman. Motion carries. I will assign that floor statement to Assemblymember Carlton. Okay, members, thank you guys all so much. I know this was a long work session. I appreciate you all being here. I want to thank our staff for getting us through yet another deadline. So thank you, everyone. The last item on our agenda is Okay, members, thank you for your patience. We are going to take, even though we are going to stand in recess, I'm going to go ahead and take public comment now so that if we do not need to meet to adjourn, we have fulfilled our obligation and taken public comment. So we've given time for those who are listening over the internet to call in. I'm going to ask broadcasting if there is anyone in queue to give public comment.
Chair, the public line is open and working, but there are no callers at this time.
Okay, then members, at this time, we are going to stand in recess. Thank you.